Welcome, everybody. Good morning. Great to see all of you. People are still trickling in, and that is fine. We're going to get started. My name is Heidi, and I am the Community Involvement Coordinator for the Greater Boston chapter of United Spinal. We are really excited this morning to have Pamela Greenfield with us. Pamela is an attorney with the Greenfield Planning Group, and she's going to be presenting to us on estate, disability, and long-term care planning, a topic that is definitely important, particularly for everybody, but particularly for people with disabilities, and in our case, spinal cord injury. A couple of things: this is being recorded, and it will be posted on our YouTube channel. So if you need to come back and revisit it, it will be there, or to share with anybody else. If you do not think that we have your email address and you would like to receive emails, updates about weekly support group meetings and events happening in our monthly newsletter, please go ahead and put your email address in the chat, because we do have some people here that I don't recognize, and that's fine. Again, please keep yourselves muted. The other thing I just want to let you know as we get going, we're going to do this in a little bit of a different format. We usually wait and hold all questions until the end, but given the nature of this talk, Pamela is going to pause at a few different points to take questions. So if you do have a question that's, kind of a burning question that you want to remember, you can go ahead and put it in the chat and we'll make sure we get to it. But just so you know, we will pause throughout the presentation, and Pamela will take questions. And I think that's it. Is there anything that I'm missing that Doug wants to jump in on, or Ryan, anything that I missed?
No, I can't think of anything.
Okay, great.
Looking forward to the presentation.
Wonderful. Okay, so I'm going to go ahead and introduce Pamela Greenfield. Welcome.
Hi, everybody. Nice to meet you all virtually. Oh, now I'm spotlighted, right?
Yes.
Okay, got it. So I am excited to be here. I'm coming to you from Needham, Massachusetts. Everybody here in this group is local or in Massachusetts, Heidi?
Mostly Massachusetts, New England area. We have people here. Well, Joe's from Wisconsin. We definitely have people that kind of join us from lots of different places. And even though this might be, and you can explain, this may be more specific to the laws in Massachusetts, there's still a lot of universal themes and understanding in this.
So that's a good point. I practice in Massachusetts. I'm not licensed anywhere else. And my practice is in Needham, Massachusetts. So I'm in the Metro Boston area. I run a small elder law and estate planning firm. And the nice thing about my practice is that I share office space with a geriatric care manager or an aging life care advocate. So that's another person who might be interesting to speak to your group. Have you had that, Heidi?
Not yet, no.
Yeah, so we could hook you up with that as well. That's another really great resource for your group. So what's nice about that is that we have the synergy in our office to talk about financial and legal planning. And then also we have clinicians here on site that can help our clients to access the care itself and determine the level of care that they need that's appropriate. So that's sort of a unique business model that's worked for us. I've been practicing for about 15 years, and my client base ranges from young families with minor kids who are just sort of
come here,
starting out and getting their estate planning. That was right on cue. The somebody's kiddo, I heard. Getting their estate planning needs and affairs in order in case anything ever happens when the kids are minors. And then I have, all the way through 100-year-old seniors who are doing their estate planning documents and everything in between. So I have a lot of clients who are accessing public benefits because they're disabled. I have clients accessing public benefits because they're seniors and they need more care at home or in a skilled nursing facility. I have clients who have disabled children who are working that piece into their estate plan to make sure that their children receive an inheritance but don't lose their public benefits. We also do court work, we do guardianship and conservatorship work, and then tons of mass health applications for nursing home residents and community-based care. And then at the end, we do some estate work as well. So that's sort of the nature of my practice. And like I said, I practice in Massachusetts. So the majority of the things I'll say today are Massachusetts focused, but the themes are applicable in, everywhere for everybody. So sort of an outline of what I'm going to talk about today. And I was telling Heidi before everybody jumped on the Zoom, my style of presentation doesn't lend itself as well to Zoom as other people's does, because I like a collaborative approach where we're sort of having a discussion and everybody is raising their hand and asking questions, and I'm happy to take questions as we go. So I can only see a few people at a time. So Heidi's going to monitor the questions, and feel free to ask questions as we go. Like I said, this works better when we're all sitting around a big table, but we'll try to do the best we can. And hopefully sometime in the future, we're able to be back to things like that. So I'm going to start out with sort of an overview of the basic documents that everybody should have, regardless of your age, your health, and your wealth. And then I'm going to jump into an overview of public benefits in general and what benefits you could possibly consider applying for, and just a general, real basic overview of how to qualify for some of these benefits. And then I'm going to talk about a little bit higher level estate planning, special needs trust planning, irrevocable trusts, things like that, to plan in advance in the event that you do ever need to apply for some of these higher level benefits. And like I said, as we go along, please feel free to shout out your questions. And if there's something on my agenda that you didn't hear that you'd like to hear, let me know, and hopefully we can work that in as well. Okay, so I sort of give this spiel to anybody from age 18 all the way to 100. There are certain documents that everybody needs, regardless of your age, your health, and your wealth, if you're over the age of 18. So for my clients who have kiddos who are headed off to college, I often say, like, let me do these documents for your kids at a very low cost, so that they're set up, because now that they're 18 years old, they're their own decision makers, and they fall into this category of people that now need these documents. So these super basic documents that everybody should have are a healthcare proxy, a durable power of attorney, and a last will and testament. So a healthcare proxy, and that's what it's called in Massachusetts. It might be called an advanced healthcare directive or a durable power of attorney for medical care in other states. But here in Massachusetts, it's called a healthcare proxy. Healthcare proxy allows you to name somebody to make a medical decision for you if you ever find yourself in a situation where you can't make that decision for yourself. A good document appoints a primary person, a primary decision maker, and an alternate decision maker. Often my clients want to go down the list. They have, 2 and 3 kids, and they want to name their spouse as primary, but they want to make sure that they're putting their kids in successive order on this document, and that's fine too. The healthcare proxy in Massachusetts is actually a state form that you can download for free. So there's really no reason not to have this document. They give it out in senior centers. You can get it at the doctor's office. And it's a super easy form to locate online. And essentially, this fill-in form just says, this is the person I appoint as my primary decision maker, and this is the alternate. That form is better than nothing, and that's saved my clients lots of money and stress, even for that freebie form. The form we do is a little bit more robust. We talk about things in our form like, would you want to be give your healthcare agent the ability to treat you with certain medications? Do you give the authorization to be moved from a hospital into a nursing home, or, for my dementia clients, to go to like a geriatric psych unit? So we put all of these authorizations in the document so that it's crystal clear to the treating physicians and facilities that our clients would have wanted their healthcare agent to be able to have the ability to make these decisions. So it's much more robust than the state form. And so there are two other documents that I do with a healthcare proxy that go hand in hand. One is called a HIPAA release form, which most of us have signed at our physician's office, but this is a specific, that's to a specific physician. I see the healthcare proxy form in here, so that's good. The HIPAA release form I do is a blanket form. So it says these are the approved individuals that can access my medical records, and it is sent to whatever doctor you need. So it's not specific to a medical institution or a specific doctor. That actually winds up being a very helpful form for a lot of my clients, because a healthcare proxy needs to be activated by a doctor. And so that's an order in the chart. So the doctor would sign an order saying, I hereby activate the healthcare proxy. So that's the terminology that is used. And sometimes the healthcare proxy is not activated because the patient is able to make their own medical decisions. So, but the family members need to get access to information as well. So the HIPAA release form is a nice add-on because it can come into play before the healthcare proxy is activated. So we really like that form a lot. And then the last form I do for my clients is a living will. So in Massachusetts, we don't have a living will statute. In other states, there is a living will statute that outlines somebody's ability to say, this is what I want for end of life care treatment. I would not want to be hooked up to life support machines. I would want to do that. I want to give my healthcare agent the ability to make that decision, or I don't. Here in Massachusetts, it's implied that the healthcare agent can make any and all healthcare decisions, including end of life care decisions. So the living will winds up being a really helpful place for my clients to outline their wishes to their healthcare agent, so that the healthcare agent isn't really making these decisions in a vacuum. So I can't tell you how many clients I've had sit in my conference room and say, it was the hardest decision I ever made to take my mom off of life support. And I still to this day second guess that decision. And I wish that, I didn't have to make that decision. So I say back to them, well, this is an opportunity to not put your own kids in that situation, because you're telling your agent, your kids, this is what I would want if the doctors are saying that I'm in a persistent vegetative state or an irreversible coma. I would not want to be kept alive on life support indefinitely. So more than anything, it's an opportunity to give your kids and your spouse and your loved ones some indication as to what your wishes are, so they're not really, that heavy burden isn't on them. So I like those three documents together as a suite of healthcare documents. Any questions about those documents in general before I move on?
Sorry, I'm just so I can kind of get a better look at the group here, I'm going to, sorry, it's taking me a moment here to get to the gallery view here. Anybody have any questions?
I have actually a question. With all these forms, is there a particular place that you should start? Do you have to start at the healthcare proxy, or can you do any of these at any given time?
Yeah, so that's a good question. I think like when I see clients, I meet with them and I do all of this together as one. So, like right now we just sort of spent a few minutes talking about the medical decision-making documents. And next I'm going to talk about the financial decision-making documents. So it's always a good idea to sort of get these basics done together at once. But I guess if you are sort of like, I need something and I don't have an appointment with a lawyer, and the one form that is available for free and online is the state healthcare proxy form. So that's a great place to start. I wanted to make a comment about the difference between a living will and a DNR. So a living will is not a legal document, but it's also not a medical document. It's just sort of a note to your healthcare agent. This is what I would want. This is what I would not want. But there is a medical form as well. And that in Massachusetts is called a MOLST form, Medical Order for Life-Sustaining Treatment. So that's actually a checklist. It's hot pink if you've ever seen it. And you'd fill it out with your physician and it would say, it's really specific. It says, would you want to be hospitalized? Yes or no. Would you want to be intubated? Yes or no. Would you want artificial hydration? Yes or no. Would you want artificial nutrition? Yes or no. And so most of my clients that have a MOLST form have chronic illnesses or have suffered traumatic brain injuries or spinal cord injuries, or they have a terminal illness as well. So typically you don't see a lot of MOLST forms in individuals who are not facing major medical issues. But that's also a form that you could consider working with your doctor on. And in Massachusetts, that takes the place of an old DNR form, which was a do not resuscitate order. It broadens that because the DNR language is in the MOLST form. But clients often ask, what's the difference between the MOLST form, the DNR form, and the living will? So that's sort of an explanation of that. Ryan, I hope I answered your question.
Yeah, definitely.
We have another question here. A living will versus advanced directive specifics. And is there a better person, an MD or an attorney, to go over what certain circumstances that might be foreseen to consider?
So this is like the specific medical circumstances So I think that's a great question. And I do think a physician is the better person to do that. And that is what that MOLST form is all about. You know, we sort of keep it, to that one very narrow decision about end of life care treatment. And this kind of, I always reference this case. I'm like so dated at this point, but if you remember that Terry Schiavo case from many, many years ago, this was a woman who, I believe, I can't remember the facts, but I think it was her husband wanted something different than what her mother wanted. Right. And they were in court, and I think it was in Florida, because the husband wanted to let her go peacefully and take her off of life support, and the mother wanted to keep her on life support. I could be conflating that, but Heidi's shaking her head. Yes,
Yeah.
Like she remembers this story.
I remember that too.
So that is the specific situation that the living will talks about and the reason why we focus on that is because that winds up being what lands in court, right? That decision, whereas the other decisions really mostly take place in a medical context. And the case law is probably focused more on that end of life care decision. So this is a good segue a little bit into, what we're sort of avoiding here with this document. And that is the going to court, right? So you have a healthcare proxy, and you have a living will, and you have a HIPAA release form. The purpose of doing that is if you ever have a major medical event or suffer from a chronic illness and you can't make your own medical decision. So like it spans the, it can be for, like I've had clients who have had major accidents and emergencies, and they don't have documents because they were healthy in their 40s and they never sat down and did a healthcare proxy. And now they're in court because medical decisions need to be made for them. So their loved ones are seeking a guardianship, an emergency guardianship. So that's what we're trying to avoid here. And then on the other side of the spectrum, it's like, you know, clients who have been diagnosed with Alzheimer's or dementia 5 years ago and then didn't do those documents. And now here we are, and there's no longer capacity to sign those documents, and there's no capacity to make major medical decisions. So we wind up in court getting a guardian appointed. It's less of an emergency in those circumstances often, but that's really what we're avoiding here. That's what we're trying to avoid, is going to court, going before a judge in an emergency situation, and having a judge step in and appoint a family member to be somebody's guardian. It's also when there's a guardian involved, it's costly, it's time consuming, it's a public event. And then that person is bound to the court. So they have to keep checking in with the court and filing reports with the court. So it's really, it's an onerous process. And there's this one silly form that can often avoid all of that. So I can't stress enough how important that healthcare proxy is.
Pamela, I don't know if that answered the question that, sorry, it's just on my screen and now I'm not seeing. Yes, if you don't have a healthcare proxy, can you use your power of attorney document
in an emergency situation?
And then we'll go to Tim, who has his hand raised.
Okay, so June, I'm going to talk a little bit about powers of attorney in a second. A power of attorney is for financial decision making, and a healthcare proxy is for medical decision making. So it's sort of apples and oranges. So the answer to that question is no. They play in two different spheres, right? So if somebody doesn't have a healthcare proxy and they need an emergency decision made, that's what the guardianship process is for.
Tim.
Yeah, Tim.
My question, can you hear me okay?
We can.
Okay. My question was on the healthcare proxy form and the MOST form. Obviously, you're going to give it to your primary care physician first to keep it on file, but in the case of an emergency situation where you end up at a hospital that you may not have used before or somewhere else, how do you ensure like that's in the system somewhere that it gets to other providers, other doctors, other hospitals in the case you're in an emergency situation sort of outside of your usual home area?
Yeah, so that's a great question, you know, and you would think that like in 2022, there would be a better system to house all of this, right? You know, like some kind of a universal system where these documents could be uploaded, but there really isn't. So when we have clients sign these documents in our office, we keep a copy here I actually don't keep any original documents. I only keep electronic files in my office. So I have uploaded to my system a copy, which will work. So sometimes I get an emergency call from a child or a family member that says, like, my mom's in the hospital, I don't have my healthcare proxy, can you email it to the social worker? So we have it. We also tell our clients to give a copy to their treating physician, whether that's the primary care or neurologist or whoever it is, the primary point of contact for like the specific medical issue that is the biggest issue. We say, give a copy of that healthcare proxy and HIPAA release form and living will if you want to the primary treating physician. And then the agents have a copy. So some of my clients who are caregivers, they have those documents on their phone, you know, so they show up at the emergency room and they're able to present it. Like, you know, it's not like if you don't have that document in the moment and it's an emergency that the staff isn't, like the medical professionals aren't going to treat this person. They are. They're required to. It's just that when we start to get into the weeds, right? And now we're talking about certain kinds of treatment or moving a person from a hospital to a rehab facility. That's really when they need to see the document itself. I hope that answers your question.
And I guess just to follow up to that on the MOST form, is there are they just direct questions, or is there do you add in to what extent you want that?
So this is a form that's readily available online. So if somebody wouldn't mind, you could put it in the chat. Like somebody was kind enough to put the healthcare proxy form from the state in the chat. If somebody could Google that and put that in there as well, you could take a look at this form. I can't remember off the top of my head whether you're allowed to add detail, but I think you can, or write it in the side. At the end of the day, like, the doctors want to do what you want them to do. Thank you, Heather. So whatever information you can provide is probative and helpful information in a crisis. So whether you can actually write it, I guess what I'm saying is, whether you can actually write it on the form or you can write it as an addendum to the form, if you feel strongly about certain things, you should definitely put it in writing and keep it with those documents so that the people making these decisions and speaking for you can really carry out your wishes.
Just so everybody knows, anything that I will, if I have your email address, I will email all the attendees afterwards, and I'll include any links that go into the chat.
Thank you.
Yeah, okay, go ahead, thank you.
Anybody have any other questions? Okay, so let me move on to to powers of attorney. So we talked a lot about healthcare documents, and I like to talk about healthcare documents because I think that that's an area where you can do this really super small thing and avoid a total catastrophe. So it's empowering in a way, because you really can really make a difference and make it easier for yourself and for your loved ones by just doing something really small and easily accessible. Similar to a healthcare proxy is a durable power of attorney. So same idea. Somebody can no longer make their own financial decisions, and they need somebody else to step in and make financial decisions for them. So this is not a form that you can get online. You really do need a lawyer to prepare a power of attorney. I always like to tell clients, this is a document that, unlike the healthcare proxy needs to be activated by a doctor. So it sort of springs into action when it's needed. A power of attorney doesn't operate like that. A power of attorney goes into effect when it's signed. So you really want to make sure that the people that are appointed in this document are trustworthy, and you've had this conversation with them. Lawyers try to do all kinds of different things, like hold the document in escrow so that it's only given out if and when it's needed. I feel like in 99.9% of the times, my clients trust the people that they're appointing on these documents. So it's okay. I don't like to give this document around like the healthcare documents. The healthcare documents everybody should have, so that it's clear this is my medical decision maker when this document is activated. And back to the healthcare proxy. I meant to say this too, as I'm explaining about the power of attorney. The later in time document controls. So sometimes, like, you do these documents with a lawyer and you have this neat estate plan all wrapped up, and the doctors have copies of the healthcare proxy and everybody is on the same page. And yet the patient is admitted to a hospital and they're handed a healthcare proxy form on admission. Like, that's part of an admissions packet. Like when I was in labor, somebody handed me that form, right? So if you sign that form, it trumps the one that you would have signed with the lawyer, the prior in time one. The latest in time healthcare document always, but especially a healthcare proxy. So you just want to be careful not to sign a new one if you've done one with a lawyer and it's all neat and buttoned up. You say respectfully, I already have one, I don't need to sign that one. So back to the power of attorney, same idea. It allows you to appoint this person or these people as your financial decision makers. Both of these documents can be changed at any time. There's no like, I did this and now it's irrevocable, or I did this and I appointed my daughter and now we had a falling out, so now I have to get my daughter to sign off on it and agree to not be my healthcare proxy or my power of attorney. These documents are changeable, amendable, revocable at any time while the person still has capacity. So a good power of attorney has like everything in the kitchen sink in the document, anything and everything from paying bills to managing assets to securing a mortgage, filing a lawsuit, filing taxes, dealing with public benefits. A good power of attorney is a lot of pages. Like my documents, I don't know, 15, 16 pages. And it can be used to sell real estate. I do 2 originals, because sometimes the banks need the original document, and the registry of deeds always needs the original document. If we're signing any kind of a real estate document through power of attorney, the original needs to be recorded in Massachusetts on the public record. And what else can I tell you? They should be updated. So all of these documents really should be updated. I would say every 5 years or so, you should open up your estate plan, look at it, make sure the people that are named are still the people you want named, and then contact your lawyer, because we're always adding new things into our documents, new powers, changing things around. And it's a good idea to, even if you're not changing anything, it's a good idea to re-sign. Financial institutions get funny about powers of attorney that are older than like 5 years or 10 years. Even though that's illegal for them to do, they still give pushback when the document's older. The last thing I'll say about powers of attorney is that if you don't have a power of attorney and somebody needs to make a financial decision for you, they're in court again, only this time it's not the guardianship process, it's the conservatorship process. So guardianship is the process that you go through to get a fiduciary appointed to make medical and life decisions. And conservatorship is the process you go through to get somebody appointed to make financial decisions. It's usually less of an emergency, but sometimes it is an emergency. Like I've definitely been in court on an emergency conservatorship motion too. It's even more annoying, the follow-up on a conservatorship, because the fiduciary who's appointed needs to account to the court on an annual basis for every single dollar that's spent and how it's used. So it's really a big task for the fiduciary. Again, having a power of attorney totally avoids all of that. This person doesn't have to account to the court. We sidestep that whole process. So what questions can I field about that document?
I'm just going to a different view here so I can see if does anyone have any questions? And you can also go ahead and raise your hand, and that helps me see if anybody.
I used to be a chemist. I was approached by the Michaelian organization.
Okay, I think that's.
I have a question.
Go ahead, Brian.
Yeah. So the person that is the power of attorney, say I chose to be power of attorney for my dad, we signed off on it and got all the documents squared away. Does that mean that I would be financially responsible for any debt that he has down the road?
Brian, that's such a good question. We get that all the time. And the answer is no. So you are serving in a fiduciary capacity for him. So your own assets and liability are not on the line. You're stepping into his shoes and you're serving as, as him. The only time I've ever seen a power of attorney on the hook financially is if they are engaging themselves in practices that are suspect, so they are misappropriating the funds or doing something self-interested or doing something illegal, things like that. But as long as you're just like, I'm going to stand in his shoes and I'm going to pay his bills and I'm going to make financial decisions for him, it doesn't impact your financial picture at all. Looks like Bernie has a question.
Yeah, we went down this road once, but I thought I'd ask the question here. Sometimes financial institutions will insist on using their own POA, even if you have a valid recent one. What should people do in that case?
Yeah, so I mean, I think that I'm probably a pushover and I prefer the path of least resistance. So if Fidelity has their own form that they want my client to sign, my client still has capacity to sign that form, I have no problem having my client sign that form. It seems like it's not worth the struggle or the trouble to tell them, you know, we're not signing your form. It just seems like pick your battles. And you know, I have 2 boys and they're constantly torturing me. And I've learned which battles to pick and which battles not to pick. And that's like falls under the category of like, if they want you to sign one more form, just sign it. It's not going to hurt. Where it's totally and completely illegal is when they've refused to honor my general durable power of attorney and they want their form signed and my client no longer has capacity to sign the Fidelity form. So that's illegal. And sometimes that requires, you know, me getting on the phone and yelling at somebody at Fidelity and saying, you know what, it's nice that you have a form, but my client has a general durable power of attorney and no longer has capacity. So you have to honor this form. And they always do, you know, I've never had to, you know, do anything more than yell at a banker at Fidelity. There's 2 hands raised, Brian and Ruth Ann.
Yeah, sorry, Brian and then Ruth Ann.
Okay.
Or Brian, did you already ask your?
No, I have one more if I could.
Go ahead, yeah, go ahead.
So this one's regarding guardianship. Is it possible to do that on your own, or do you have to get a lawyer involved?
So Brian, like so just to clarify, to serve or to do the paperwork to get appointed?
Well, I guess let me give you a quick backstory without taking up too much time. I have an aunt that's mentally disabled.
Yep.
And my dad is her guardian. They went through the whole process years ago, you know, if not decades ago, to make him her legal guardian. But he's getting up there in age. So, you know, with trying to think ahead, planning ahead, I'd like to get myself on there as well. But I know it was such a process when he did it. They had to have, you know, a lawyer involved. They had to have a psychiatrist come out, whole 9 yards. Yeah. Is that still the process?
Yeah. So again, and you know, not a knock to your aunt, but this is why we want to stay out of court if we can. You know, this is why healthcare proxies and powers of attorney are like the preferred method of having fiduciaries appointed, because the court does not make it easy to do anything. I would say, I mean, I'm not going to say that it's impossible to do this pro se and file the paperwork with the court. You know, it's possible to go in and talk to a clerk there who gives you the right forms and gives you the right instructions and sort of helps a non-attorney navigate through the process. I would say that it's possible that you could wind up having that circumstance, but the overwhelming likelihood is that it won't go down that way and that you're going to just be banging your head against the wall saying like, this is such an archaic and counterintuitive process. And it probably makes sense to have a professional do it for you. And unfortunately, exactly what you're describing happens all the time where, you know, somebody is appointed as somebody else's guardian, but then that person, you know, has been that person's guardian for many, many, many years. And the fiduciary is now getting up in years. And you want to say, I have a case like this right now where one of my clients has her sister as the fiduciary, and now she wants to have like now we want to get the daughter appointed with the sister because the sister is older, and we want to make sure there's a smooth transition there. And the court process to do that is totally counterintuitive. We have to get rid of the old guardianship and do a whole new guardianship. So that's what you're explaining that you experienced before. And there's no like easy way to like add another person. It's really unfortunate. It should be easier, but it's not.
Thank you.
And then Ruth Ann.
Yes, hi. To go back to your question earlier, talking about fidelity and the what is the exact definition of unable to sign? Because you have people with a low cognitive testing levels, and you have dementia people. Yes, physically they can sign, but mentally they don't know what they're signing.
So that's a great question too. So the physical aspect of it is of no consequence. So there are many, many ways that I can have a client sign a power of attorney. Like I've had plenty of clients who are able to sit here and have a conversation like this with me, but they just can't move their arms. I mean, we're at a spinal cord injury group here today, right? So this is not like a phenomenon that you guys aren't familiar with. There are many ways to get that done, whether it's I'm signing for them at their direction, and then I'm signing a notary block that says I was given the authority to sign this. And this is actually all in the notary statute, ironically, or a notary standing order. There's another way to do it is like sometimes my clients, like I've had Parkinson's clients that can't sign their name because they can't hold the pen long enough, but they can make an X, right? So that's sufficient too. Other times, like I can grab a client's hand and guide their hand along and, and sign that way. All of those ways to do it are acceptable. There's ways to do that under the law. The thing we can't get around is the cognitive piece. So, and that's a squishy thing. That's a subjective thing. So I've met with clients who are, the standard is essentially competency in the moment. So some of my clients who I can sit across and they can say, yes, this is my daughter. I have 3 kids. I trust all kids implicitly. And I'm going to sign this power of attorney and healthcare proxy, appointing my kids as my decision maker. And they can get the general concept of like, these are my kids and I trust my kids and they're going to make decisions for me. And then if I went back later that afternoon and my client said like, I've never seen you before in my life, that's actually okay, as long as there was competency in the moment. Now, if I went to court on that, would I want to go to court on a situation like that and have that challenged? Not really, but the way the law is written is it's competency in the moment,
Okay. Perfect. Thank you.
Great. Sorry, I'm trying to follow. So Thomas had a question and then Steve. Thomas is asking what type of costs are associated with having these documents completed?
Yeah, so that's a fair question. I hate when lawyers are like, oh yeah, I'm not going to share my fees. That I just think that's you need to be as transparent as you possibly can be. We really try to keep our costs. Every lawyer is different. Some lawyers will charge hourly to do these documents. And I have colleagues who do that and they say my hourly rate's $350 and I expect this to be, 5 hours of my time and I'm going to charge hourly. But the majority of elder law and estate planning attorneys tend to do this on a flat fee basis. I really feel strongly that everybody should have these documents, and I'm not, this is not where I think like our law firm makes our money, because these documents are simple to do and anybody can do them. So I try to really make this affordable for people. So a basic estate plan, powers of attorney, healthcare proxies, and a last will and testament in my office is under $1,000. So, we're not talking big bucks here. but I have colleagues that charge $2,000 or $3,000 for a basic estate plan. You know, once you start adding trusts in for various things, it gets a little bit more pricey, but I really believe that these documents should be priced in a way that is affordable. So, you know, I could elaborate on that more, but it's hundreds of dollars, not thousands of dollars.
Thank you. Steve.
I wanted to ask a question about having multiple powers of attorney or multiple people sharing the power of attorney. Can you do that? And what do you think of, if you can, what is the advisability?
Yeah, so that's a good question too, Steve. So in the healthcare proxy context, I flat out don't allow my clients to do it, because I don't think this healthcare proxy statute allows for it. So I tell my clients, I know this is a difficult decision, but unfortunately we can only have one person serving in each role at a time, because the doctors really need one point person to talk to make the decision. And I say, you know, you put your other kids on that HIPAA release form, so the other kids have access to the medical information, you know, and you tell everybody to work together and consult together, but we need one point person. When it comes to a power of attorney, I'd say my preference is to have one person serving at a time, but I recognize that a good team together can like divide and conquer a difficult and challenging situation. So I tell my clients that it's fine to appoint two people together in that role, as long as we're appointing them jointly and severally, meaning two people don't have to both sign off on everything, because that winds up being extremely cumbersome. So I say right in the document, they're serving jointly and severally, so they each can act without the other one. And the other thing that you would just not want to do is appoint two people in that role that don't get along with each other. So if I have a brother and a sister that get along, like they're a great team and one is good at investing and the other one is good at bill paying, I'm totally fine with that. What I can't let my clients do is my son and my daughter haven't spoken to each other in 30 years. I'm going to appoint them together on this document and hope that this is the moment that they are reunited as a team. That's not good lawyering.
Okay, thank you. Okay, I'm going to go ahead and spotlight you again, Pamela.
Oh, okay.
And just quickly again, I will, is whatever information I have, I will be putting it into an email. Lots of you I know who are on the screen. Many of you, if you just have a first name or an initial, I don't know who you are and I may not have your email address. So please message me if you would like me to be able to contact you, send you an email. Thank you.
So the last document I'm going to talk about today that's part of that basic suite of documents is a last will and testament. So everybody knows what a last will and testament does. It allows you to say who inherits your estate when you pass away, and it allows you to name an executor, or in 2022 terminology, personal representative. That's the word we use now, of your estate. But what not everybody knows is that what assets does a will have control over? So this is always, people are always like, wow, I never knew this. So a will only has control over what are called probate assets. And probate assets are assets that are in your name alone, with no beneficiaries named and no joint owners. So an individually owned bank account is a probate asset. A life insurance policy with a beneficiary named on it is not a probate asset. An IRA with a beneficiary named, not a probate asset. A jointly held bank account with one of your kids, not a probate asset. If you own your house as joint tenants or tenants by the entirety with another person, it's not a probate asset. So a will only has control over those assets that don't have an internal mechanism to be passed on when the person passes away. So naming a beneficiary
naming a joint owner in a way that supersedes what a will says. So your will could say, I leave everything in equal shares to my 3 kids. But then if you have all of your bank accounts jointly held with one of your daughters, the assets are going to pass to your daughters, to your one daughter, the joint owner, not according to the terms of your will. So you just want to make sure that you're being consistent there. The other thing is that everybody should have a will, but the goal 9 out of 10 times is to not use the will, because we don't want to go through probate if we can avoid it. We want to avoid probate. We want the theme of this program today is avoid the court wherever you can. So we don't want to go into court for guardianship and conservatorship, and we don't want to go through court to distribute an estate either. So there's better ways to do it are to use these beneficiary designation forms and have joint ownership where it's appropriate. And then use trusts, because the world of trusts sidesteps the probate court. So trusts are, everybody's always afraid of what's a trust, you know, and you have this vision in your mind of like trust fund kids. A trust is just an instrument, just papers that that says what goes on during the life of a person, and then what happens when that person passes away with respect to the things that are physically put inside of the trust. So trusts are great because they sidestep that probate court process, and they allow us to do so many more things than what a will can do, which is just distribute the assets. Trust can do things like hold assets for a longer period of time. So for my clients with minor kids, the trusts can say things like, if anything happens to the 2 of us while our kids are minors, everything goes into this trust. And then when the kids are 25 years old, the trustee can make an outright distribution of 1/3. And then at age 30, they can make an outright distribution of another 1/3. And then at 35, they can distribute the remainder of the trust. You don't have the ability to do that in a will. A will just says where the assets are going. I know we don't have a lot of, I mean, maybe we do, but the other important part about a will is that it's the place for you to name guardians of your minor kids. So if I have folks on the call that have minor kids, the will is really important because that's where you would identify who you would want to, be the decision maker for your own kids. But at the same time, that's not the place where you would likely want to deal with your assets. I threw a lot out at you all, so I'm sure there's questions.
Can I ask a question?
Yeah.
So the question really is, so for instance, if I am able to be in charge of my son's needs and decision-making, but then God forbid something happens to me, my son's autistic and he's got, some challenges. So would I put in a will that I am having maybe one of my older children become who I am for him now, or because he's older, my son's 20 years old. So like, how does that work then? Because
that's
a
really good question too. Huh? So it's, that you just reminded me. So are you serving, Janet? Are you serving as guardian for him?
Well, so we haven't gotten that far, but okay. We want to because, we had all kinds of problems when he had his injury because we weren't guardians.
So under the law in Massachusetts, parents of minor children can name a guardian for their kids. That person would then need to be appointed. So the court wouldn't just like automatically say, okay, Janet, somebody said that Pam Greenfield said that she wants XYZ to be the guardian of her boys when she passes away. So that's automatically what happens. You'd still have to go through the court process, but the court gives a lot of weight to the decedent's wishes in a will for minor kids. There's another provision of the probate code, the Uniform Probate Code, that allows a person who is currently serving as guardian for somebody
to do that as well. So you could do that in your will. You could say, I have a son who's going to need a guardian, and this is who I would pick for him. Again, the court would have to go through their regular normal process to get this guardian appointed, but being that the guardian, the existing guardian gave, left a name and said, like, this is who I would trust to serve in my shoes, that's extremely probative information for a judge to hear. So I would advise doing that. And, while we're on the subject of disabled children, this is not like always super clear. I've had through the years clients whose kids are clearly not able to make decisions for themselves, but they are able to identify a decision maker, right? So, and this comes up with special needs kiddos that are not, that aren't necessarily cognitively impaired or intellectually disabled. So, I guess what I'm saying is I've had through the years clients that say, oh, I probably need to become my son's guardian because I won't be able to make decisions for him otherwise. But then we talk it through and we land on the fact that, well, wait a second, my son might be able to sign a healthcare proxy and a power of attorney, and that might be all I need. So with that, what I'm saying is that that's not always clear. As you know, Janet, like, you might need guardianship, but you might not need guardianship. So it's good to talk that through, if that makes sense.
Right. So this is rather extensive. Our situation was very particular, where you're right. My son has some limitations, not all, but the circumstances would have benefited him best if we were guardians. And we didn't even know we could have done that before he graduated high school. And like all these things that we're learning, but I guess we'll have to contact you after the fact. Thank you.
Yeah, I'm happy to help. And I should have said this at the beginning, we obviously run a law firm. We have lots and lots and lots of clients that we help, but I'm also happy to be a resource. We are not always the right lawyer for the job. And I have a really good network of folks that handle different things. And so I might be able to point you in the right direction, even if I'm not the right person for the job. I see two other hands.
Sue and then Tim. Thank you.
Good morning. Thank you for this informative forum. I had a question about if a person has an ABLE account in a different state, is it recapturable in Massachusetts? And has the current amount changed?
Sue, you might have stumped me. I don't actually do a lot of work with ABLE accounts. What I can say, so when you're asking, is it recoverable for mass health purposes?
Correct.
So Mass Health is a creditor of the probate estate in Massachusetts for Massachusetts assets for people that have received benefits from age 55 and later. So if the person's under 55, there's no estate recovery unless the person was in a skilled nursing facility. So you might be outside of that. I don't actually know what the ABLE laws are. I don't know enough about, I don't know if the ABLE accounts in and of themselves have to name the state as a primary beneficiary, but I could look that up and get back to you on that fairly quickly.
Yeah, just because these accounts are so new, and of course, Massachusetts finally caught up with the other folks.
Yeah.
And got this started. But there are other states and commonwealths that don't require recapture. And I'm hoping Massachusetts will go that route because it's not like there's a whole lot of money, but it's all within the whole estate planning, right?
Yeah.
But thank you.
I can look into this for you. And I don't know if the amount changed. The amount was, correct me if I'm wrong, but it was 15 grand per year, right?
to what? Be put into the account?
Yeah.
14,000. But
14,
I think
yeah.
that changed, but you know, it's constantly catching up.
Yeah, it's funny. My client base skews older, and we don't use ABLE accounts a lot. So it's not super accessible in my brain, but it's something I could get you the answer for.
Yeah, just because the population of people who have certain injuries tend to be younger. And so
Yes.
because these ABLE accounts are, you know, if you're disabled before the age of 26, and of course, all our risk takers are between 18 and 25.
Right.
But thank you so much.
We'll get that info for you.
Thank you.
Great. Tim.
Yes, I just got a question. If the goal is to avoid probate, is it advisable to do a transfer on your will to say that, you know, all things that are involved in probate be transferred to my trust, my living trust, and that avoids probate?
So what you're describing, Tim, is what's called a pour over provision. And yes, we do recommend that. So if I'm going to do an estate plan for somebody and I'm going to do a trust, the will is almost always going to say anything I have pours into my revocable trust or whatever trust. But incidentally, that doesn't avoid probate. So probate is avoided when the assets themselves are placed in the trust or have beneficiaries named. So if you have a bank account that has $100,000 in it and there's no beneficiary, no joint owner, and you have a will that says, I leave everything to the Tim Donovan Family Revocable Trust, you still have to go through probate to get that asset through the estate and then fund the trust. So the better approach, working with a lawyer, if this is the goal and this is appropriate, you would title the $100,000 account in the name of the trust while you're alive, or name the trust as the beneficiary on that bank account, if that makes sense. That's how you avoid probate. So the purpose of having a will is it's a catch-all, so that it ultimately redirects the asset that we didn't properly fund into the will, so that it ultimately into the trust, so it ultimately makes it to the right place at the end of the day. But it unless the trust is properly funded while you're alive, you're not avoiding probate, if that makes sense.
Yes. Yep. Thank you for your answer. Helpful.
You're welcome.
Thanks. We'll go to Steve, but I just want to check in with you, Pamela, on time, how I feel like, I don't know, that we might need a part 2, but
yeah, there's so much to cover. I mean,
yeah.
I feel like I'm happy to stick with the estate planning piece and come back another time and talk more about public benefits. There's a lot to cover. And I mean, as far as I'm concerned, if folks are getting a benefit from, you know, the conversation we're having, then
sure,
you know,
absolutely.
Okay.
Absolutely. Okay, great.
I don't, if you'll have me, Heidi.
Absolutely would love that. And this is fantastic. And it is a lot of information. I just want, I guess we'll let people know that we will plan to have a part 2, because there are a lot of things that we didn't get to cover, and that's fine. These are all great questions. So Steve and then Joe.
Okay, you've talked about the use of trusts to avoid probate and to give you flexibility in estate planning. But I wonder about the use of trusts to protect assets, in particular a house.
Yeah.
Could you expound on that a bit?
Yeah, so I mean, this is a good segue. So what I was sort of going to head towards next was, you know, giving a little bit of an overview of public benefits and how to access those public benefits. And what you're alluding to, Steve, is, okay, so now you're in a situation where you have some assets, whether it's cash or it's a house, and, you know, could we use trusts in some way to protect these assets, either for yourself or for your loved ones after you pass away, so that we can access those benefits and also preserve those assets, right? So that's, to be honest with you, that's where I spend a lot of my practice, is in that world. So I used to work for a lawyer in Southeastern Mass who used to say, trusts are like a box of chocolates. You never know what you're going to get, right? So there are trusts for all different things. There are trusts to avoid probate. We talked about that already. You know, you put these assets, all trusts avoid probate, but some trusts, a lot of the trusts I do, that's all they do. Put the assets into the trust, we sidestep the court process, and it just makes it easier to pass on property. Then there are other trusts that do what I talked about before, which is you have minor kids or you have disabled kids, and you don't want those kids to get that money outright or even at all, right? So you use a trust vehicle to make sure that these kids don't get the money outright. It's held for longer. So the trusts hold the shares for longer or forever in some cases, so that a child never has direct access to the money. We also use trusts. I don't do a whole heck of a lot of this because it's just not my specialty, but there are other kinds of trusts that we use to reduce estate taxes. So Massachusetts has a $1 million estate tax threshold. So you can use trusts to minimize the estate tax you would pay in Massachusetts by leaving your estate in sort of a specific way that uses these tax shelters. And then there are other trusts that I use all the time for disabled individuals. So and just to give you the overview of these kinds of trusts, they're either self-settled supplemental needs trusts or they're third-party created supplemental needs trusts. So self-settled supplemental needs trusts are for folks who are under the age of 65 and have some assets in their name and are looking to qualify either now or in the future for some kind of a public benefit that caps your assets. So the public benefits programs that might cap your assets are the Social Security program, SSI, Supplemental Security Income. You can't have more than $2,000 and be eligible for that program. And then the other program that caps your assets is the Mass Health program. If you're over 65, or if you're under 65 and you're accessing like a nursing home level of care, whether that's at home or in a skilled nursing facility. So those types of trusts, self-settled supplemental needs trusts, we are often called D4A trusts, and they are created by the federal law, the federal D4A statute. Third party created, and essentially the last part of that puzzle that I'll say is you, the disabled individual, would put their assets into this kind of a trust, and you would name a trustee to hold and manage the money for you, so you could have your benefits and your benefits wouldn't be impacted, but you could also have this money as long as somebody else is managing it. Those trusts require something called a payback provision, which Sue was talking about before, which is when the disabled individual passes away, the state wants to be reimbursed for what they've paid for your care. That's called a payback provision. So that's sort of a quick and dirty overview of D4A trusts. Another type of trust that we use is a third-party created trust. So if my client, the parent, for example, wants to set up a trust for their disabled child who's on one of these public benefits, they can set up this trust, and then that trust can be funded at the parent's death or during the parent's lifetime. And those funds are held in a separate trust for the child's benefit. But because that trust was created by the parent with the parent's money, as opposed to by the child with the child's money, that trust doesn't need to have a payback provision. So I always like to tell folks that have disabled children, you don't need to skip these kids. It's like a knife through my heart when my clients come in and they say, I have a disabled child, so I've left that child out of my estate plan and left everything else to my other two kids because I can't leave anything to that child. you can, you just have to use a specifically created trust so that your child's not going to lose their benefits. Okay. The last sort of category of trusts that we use to protect assets are for seniors that are looking to put their assets into some kind of a vehicle in case they ever need nursing home care in the future. So these are folks that are over 65, right? And they want to take steps to protect assets for their kids, not for themselves, for their kids, in the event that they ever require a nursing home level of care, because they've heard there's a 5-year look back period. And if I go into a nursing home, the state's going to take my house or put a lien on my house. So Steve, this might be what you were sort of alluding to before, right? So these trusts are often called irrevocable trusts. So far we talked about a bunch of different kinds of trusts, but the ones that are protective in nature are the first party created trust for under 65, the third party created trust where you as the client are leaving assets in trust for a disabled child. And then this last category is, I'm healthy and I'm approaching, my 60s and 70s, and I want to take steps now to trigger a 5-year look back period and protect some assets for my kids in the future. Often those trusts are what we just call them irrevocable trusts, and you give up a lot of sticks and carrots in this trust so that the state views it as though you've given away these assets. So if you later apply for the program after 5 years, they're not includable in your picture, your profile. So a lot of the time we put people's homes into these trusts, and there's a 5-year look back period for the nursing home mass health program. So we say you can't apply for the nursing home mass health program for 5 years. The trusts allow, the way I draft them, my clients can live in the property that the trust owns. The property can be sold at the beneficiary's direction. The proceeds can be invested, and the beneficiary can get the income earned off of the proceeds. So you put a house in, the house sells, that money can be invested, and then the beneficiary can get the interest income. If it's real estate and it doesn't sell, the person could move out and they could rent the property and get the rental income. So it's an income only trust. So you can live in the property, you can get whatever income the property produces, whether it's cash or rental income. It can be sold and it can go from one house to another house. What you can't get at is principal. So if you put a house in Newton in this trust and it sells for $1 million, and then you want to take that money and you want to buy a house, a condo in Florida, you can do that. But let's say the condo in Florida costs $500,000, right? So now the trust owns two things. It owns $500,000 in cash and a $500,000 condo in Florida. You can't move into the condo in Florida and then live off the $500,000 in cash. So in the trust, you give up principal. So this is an appropriate planning tool that we use often for our clients in some situations, but it's really only appropriate for clients that are not going to need to tap into the equity in their house, right? So I don't do it lightly. I only do it, when clients have enough money outside of the trust to finance the things that they need in their care, and they want to take this extra protective step to guarantee that their kids are going to get an inheritance. When I first started practicing 15 plus years ago, we did a lot more of these trusts, but they're really only beneficial if a person's in a nursing home. And in the last 15 years, there are so many more options in the marketplace for care: home care, assisted living, memory care, assisted living. And the state has not caught up yet in financing those programs. So essentially it pigeonholes folks to needing nursing home care and sometimes doesn't lend itself to taking advantage of the pay-as-you-go programs. So I don't do it lightly, because I say to my clients, like, this isn't benefiting you. This is only benefiting your kids, right? So we only do it when it's not really going to impact the parents' ability to pay for themselves. That's a lot.
Are you saying, are you saying that if you are at home, that there's less of a chance that the state will have a claim on your assets compared to if you're in a nursing home?
Well, no, that's a good question. So if you're over the age of 55 in Massachusetts, the state is keeping, if you're on Mass Health, the state's keeping track of what they pay for your care. If you're in a nursing home, no matter what your age is, they're keeping track of what they pay for your care. That's the estate recovery unit. So the concept of, so Massachusetts has limited itself to only assets that pass through the probate estate, right? So if you're at home and you're on a Medicaid program at home, there's no look back period for those programs, and you have a lot more flexibility. So you could be on a Mass Health program in the community and put your house into a less protective trust, like a revocable living trust, or you could have a life estate deed, or you could have your kids on your deed with you. As long as your house is not going to pass through the probate estate, the state can't collect its lien. The business with the nursing home and why people do this in advance is that anything you do for nursing home Mass Health triggers this 5-year look back period, and a plain old revocable trust won't do the trick. It has to be an irrevocable trust. So this is really nuanced, but the takeaway is if you're on any kind of Mass Health program, you want to consider not having your asset in your house in your name alone, because if you pass away and your house is in your name alone, the state could go after it. That is sufficient for community-based programs, but it's not sufficient for nursing home Mass Health. So for nursing home Mass Health, you'd have to do something more than that. Does that answer your question?
Yes, it does. Thank you very much.
And Mark,
it's tricky.
Oh, sorry. Mark asked, does the third-party trust only apply to children or a spouse as well?
That is, I know I keep saying this, I sound like a broken record, but so many good questions. So the question is, can a spouse set up a third-party supplemental needs trust for their spouse? I believe, I'm trying to think this through. That doesn't work for nursing home Mass Health, Mark. So for example, if I have a client who is living at home and they're healthy and their spouse has a diagnosis of dementia, let's say, and that spouse might eventually wind up in a nursing home on Mass Health, the ill spouse, I advise my client to do something called a will with a testamentary trust. So this is something we didn't talk about yet. But for the nursing home Mass Health program, a regular third-party supplemental needs trust won't work. It's got to be this other animal, which is a trust created by the will. So do you remember way back I said in 9 out of 10 times we don't want to go through probate? The only time we do want to go through probate really is when I have a situation where I have one spouse in a nursing home and the other spouse in the community, and the spouse in the nursing home is on Mass Health or could be applying for Mass Health benefits in the nursing home, and the spouse in the community wants to wants to make sure that they take care of their spouse that could need a nursing home level of care. The only way to make those assets non-countable for the nursing home Mass Health program is to do it in this will with a testamentary trust way. If you use a regular third-party created supplemental needs trust, it won't work for nursing home Mass Health. I don't actually know whether it would work for SSI, but my inclination is no, that will with a testamentary trust needs to be the preferred method for not losing SSI benefits. But if your spouse is not on any public benefits, or they're on a public benefit that doesn't have an asset cap, like SSDI doesn't have an asset cap, and you're just sort of worried about your spouse's direct access to the money because maybe they're not so good with money, or maybe they just cognitively can't manage it, but they're not on any public benefits and they're not really going to ever be on any public benefits, you could use a regular third-party trust, but it's not going to do the trick for nursing home mass health. Does that answer your question? I'm happy to help if anybody needs my help, but that's usually what I do for clients that have somebody's in a nursing home or could go into a nursing home. You have to do this third option of a will with a testamentary trust. The Medicaid rules require that. So I know I only have like 5 minutes left. So there's, I touched on public benefits a little bit and planning for it. I mean, again, I could talk for hours on that alone, but just, before we wrap up, I hope I didn't confuse people too much. There are certain public benefits that are cash in your pocket. And then there are other public benefits that are health insurance benefits, right? So the cash in your pocket tends to be the SSI and the SSDI. SSI has an asset cap, like we said, it's $2,000. There's other requirements of how you get there, but for my purposes, that's really important. SSDI, you could have $1 million in the bank. You've worked and you've paid into the Medicaid system, or you are collecting under somebody else's number that has done that. And there's no asset cap for SSDI. So if I was working as a lawyer and, God forbid, I had a major accident or a medical event and I could no longer work, but then I would get SSDI, not SSI, and it wouldn't matter that I have money in a 401k and I own a house and I have, millions and millions of dollars in my name, which I don't. But none of that would matter. All that would matter was that I have a work history. And then in Massachusetts, when you get SSI or you get SSDI, you automatically get mass health. It goes with it. So if you're under 65, there's no asset cap for mass health. If you're over 65, there are nuances about that. Like, for example, if you're needing home care benefits and you're over the age of 60, there is an asset cap. If you're in a nursing home and you're any age, there is an asset cap. Income is treated differently for all different kinds of mass health programs. And then Medicare also comes hand in hand with Social Security, with SSI and SSDI, but there's usually a 2-year waiting period before you can access Medicare benefits. There's other programs too, Section 8 housing, food stamps. Those are all, smaller programs that have all different kinds of income limits, but not asset limits. Do I have time for any more questions?
I'm trying to see if there's any that could be quickly answered. Mary is asking, she wants to put her house in her daughter's name also. What type of a lawyer would help her do that?
Put her house in her daughter's name?
Yes, she'd like to put it in her daughter's name as well, add her daughter to it.
Okay, so I mean that any kind of an estate planning lawyer could help you do something like that. Adding kids onto deeds is always risky business. It's not that it's not appropriate or that it's not the right approach for you, but it's not something to be done lightly because it has tax implications and it has liability implications. So you just want to make sure you're vetting that. Same thing with adding kids' names onto bank accounts with you. Kids get divorced, they get sued, they have businesses that go down in flames, and you just want to be careful when you're adding kids as joint owners to things, because their liability transfers to your asset and your tax basis transfers to them. So that could be problematic down the road when you liquidate assets. It could just not be a favorable tax result. So there's often better ways to do it than adding kids as joint owners, but sometimes it works. And if you meet with an estate planning lawyer, you could talk about all the different possible options.
Great. Thank you. Are there any last minute, sorry, I'm going to actually unspotlight you. Oh, okay. Sorry, I'm trying to just see everybody on the screen. Yeah, this is amazing. Thank you so much information. And I'm really happy that that we've agreed that you will come back for a part 2 because any last minute questions that anybody might have? Trying to just scroll through the chat. I didn't think anything popped out at me. I guess I missed anything.
Mark did ask if you could share your contact info. I know that you probably don't want to get inundated with questions through your contact info, but maybe your website or something like that so people can.
Yeah. So Heidi, do you want to send it around to the group?
Yes, I'm going to do that. Yeah.
Yeah, for sure. Send my, my website, my email address. I'm happy to be a resource for folks now or in the future. And like I said, we're a busy practice and we're always taking new clients and I'm very upfront and honest about the cases that make sense for me to take. And if it doesn't always make sense for me, then we have a really good network of folks that we refer out to as well.
Yeah, Keith is asking about the YouTube channel. I'm assuming you mean the one for the GBC. So what I will do is before I send out the email with the information on it and Pamela's contact info, I will also include the link to this presentation for anyone who wants to go back to reference it.
Thank you.
Yes, of course.
Thanks, everybody. It's been lovely to spend my Saturday early afternoon with you.
Yes, thank you.
Thank you very much.
Thank
you so much.
No problem.
Very good.
Well done. Stay dry today. It looks a little better tomorrow.
Yeah.
Thanks so much.
Thanks, Pamela.
Take care. Take care, everybody.